difference between the distribution of this movie on video demand and providing access on the Internet, providing DVDs either through a commercial service or maybe in a public library, providing the same thing in a book. Would the Constitution permit the restriction of all of those as well?
I think the Constitution would have permitted Congress to apply the electioneering communication restrictions to the extent that they're otherwise constitutional under Wisconsin right to life. Those could have been applied to additional media as well. And it's worth remembering that the pre-existing Federal Election Campaign Act restrictions on corporate electioneering, which have been limited by this Court's decisions to express advocacy.
That's pretty incredible. You think that if a book was published, a campaign biography that was the functional equivalent of express advocacy, that could be banned?
I'm not saying it could be banned. I'm saying that Congress could prohibit the use of corporate treasury funds and could require a corporation to publish it using its.
Well, most publishers are corporations. And a publisher that is a corporation could be prohibited from selling a book?
Well, of course, the statute contains its own media exemption for media.
But I'm not asking what the statute says. The government's position is that the First Amendment allows the banning of a book if it's published by a corporation.
Because the First Amendment refers both to freedom of speech and of the press, there would be a potential argument that media corporations, the institutional press, would have a greater First Amendment right. That question is obviously not presented here. The other two things.
Well, suppose it were an advocacy organization that had a book. Your position is that under the Constitution, the advertising for this book or the sale for the book itself could be prohibited within the 30-day period.
If the book contained the functional equivalent of express advocacy, that is, if it was subject to no reasonable interpretation.
And I suppose it could even, is it the Kindle where you can read a book? I take it that's from a satellite, so the existing statute would probably prohibit that under your view.
Well, the statute applies to cable, satellite, and broadcast communications. And the Court in McConnell has addressed this question.
So just to make it clear, it's the government's position that under this statute, if this Kindle device where you can read a book, which is campaign advocacy, within the 30-day period, if it comes from a satellite, it can be prohibited under the Constitution and perhaps under this statute.
It can't be prohibited, but a corporation could be barred from using its general treasury funds to publish the book and could be required to raise funds to publish the book using its PAC.
If it has one name, one use of the candidate's name, it would be covered, correct?
That's correct.
If it's a 500-page book and at the end it says, and so vote for X, the government could ban that.
Well, if it says vote for X, it would be express advocacy, and it would be covered by the pre-existing Federal Election Campaign Act provision.
No, I'm talking about under the Constitution, what we've been discussing, if it's a book.
If it's a book and it is produced, again, to leave to one side the question of
Right, forget the
possible media exemption. If you had Citizens United or General Motors using general treasury funds to publish a book that said at the outset, for instance, Hillary Clinton's election would be a disaster for
No, take my hypothetical. It doesn't say at the outset. It runs, here is whatever it is. This is a discussion of the American political system. And at the end it says vote for X.
Yes, our position would be that the corporation could be required to use PAC funds rather than general treasury
And
funds.
if they didn't, you could ban it.
If they didn't, we could prohibit the publication of the book using the corporate treasury fund.
I wonder if that's — I take it the answer to the question, can the government ban labor unions from saying we love this person? The corporations, we love them. The environmentalists saying we love them, is of course the government can't ban that. The only question is who's paying for it. And they can make a determination of how much money the payors can pay. But you can't ban it.
That's correct. And
if that's correct, then I take it the interesting question here would be, I don't know if it rises in this case, suppose there were a kind of campaign literature or advocacy that either A corporation had to pay for it. It couldn't pay for it through the PAC because for some reason I don't know the PAC, and there's no other way of getting it to the public. That would raise a constitutional question, wouldn't it?
It would raise a constitutional.
Is that present in this case?
It's not present in the case. I don't think it would raise a difficult constitutional question because presumably if the reason that the corporation couldn't do it through the PAC, the only reason I could think of would be that it couldn't find PAC-eligible donors who were willing to contribute for this speech. And if that's the case, the corporation could still be forbidden to use its general treasury.
I know about that one. I would guess I would be worried if, in fact, there was some material that couldn't get through to the public. I would be very worried. But I don't think I have to worry about that in this case, do I?
That's correct, both because the question isn't presented here and because Congress —
Well, but if we accept your constitutional argument, we're establishing a precedent that you yourself say would extend to banning the book, assuming a particular person pays for it.
I think the Court has already held both in Austin and in McConnell that Congress or state legislatures can prohibit the use of corporate treasury funds for express advocacy.
To write a book. To pay for somebody to write a book.
Well, in MCFL, for instance, the communication was not a book, but it was a newsletter. It was written material, and the Court held that this was express advocacy for which the use of corporate treasury funds would ordinarily be banned. It held that because of the distinctive characteristics of the particular corporation at issue in that case, MCFL was entitled to a constitutional exemption. But I think the clear thrust of MCFL is that the publication and dissemination of a newsletter containing express advocacy could ordinarily be banned with respect to the use of corporate treasury funds.
Not just a news, I suppose a sign held up in Lafayette Park saying vote for so-and-so. That, under your theory of the Constitution, the prohibition of that would be constitutional.
Again, I do want to make clear that if by prohibition you mean ban on the use of corporate treasury funds, then yes, I think it's absolutely clear under Austin, under McConnell, that the use of corporate treasury funds could be banned if General Motors, for instance, wanted to be
and you get around the fact that this would extend to any publishing corporation by saying that there is a media exemption because the Constitution guarantees not only freedom of speech but also of the press?
Well, there has always
Does the press mean the media in that constitutional provision? You think in 1791 there were people running around with fedoras that had little press tickets in it, press. Is that what press means in the Constitution? Doesn't it cover the Xerox machine? Doesn't it cover the right of any individual to write, to publish?
Well, I think the difficult constitutional question of whether the general restrictions on use of corporate treasury funds for electioneering can constitutionally be applied to media corporations has never had to be addressed because the statutes that this Court has reviewed have —
Well, I don't see any reason why it wouldn't. I'm saying there's no basis in the text of the Constitution for exempting press in the sense of the Fifth Estate.
In any event, the only question this Court would potentially need to decide in this case is whether the exemption for media companies creates a disuniformity that itself renders the statute unconstitutional. And the Court has already addressed that question in McConnell. The claim was made that because media corporations were exempt, there was inequality of treatment as between those and other corporations, and Congress said no, this Court said no, Congress can protect the interests of the media and of the public in receiving information by drawing that line.
I want to know how far your argument would go. What if a labor union paid an author to write a book advocating the election of A or the defeat of B, and after the manuscript was prepared, they then went to a commercial publisher, and they got a Random House. Random House says, yeah, we will publish that. Can the distribution of that be in effect subject to the electioneering ban because of the initial labor union investment?
Well, exactly what the remedy would be, whether there would be a basis for suppressing the distribution of the book, I'm not sure. I think it's clear under
does it come within electioneering because of the initial subvention to the author?
It wouldn't be an electioneering communication under BICRA because BICRA wouldn't apply to the print media. Now, it would potentially be covered by the
No, but we're talking about how far the constitutional ban could go, and we're talking about books.
Well, we would certainly take the position that if the labor union used its Treasury funds to pay an author to produce a book that would constitute express advocacy,
and the book was then taken over as a commercial venture by Random House.
The labor union's conduct would be prohibited. The question of whether the book that had already
No, but the prohibition only comes when we get to the electioneering stage.
That's correct.
Okay.
The question whether
so for the labor union simply to hire is there an outright violation when the labor, I guess this is the statutory question, is there an outright violation when the labor union comes up with the original subvention?
I guess I would have to study the Federal Election Campaign Act provisions more closely to see whether they
Let's assume for the sake of argument that there would not be. The subvention is made, the manuscript is prepared, Random House then publishes it, and there is a distribution within the the 60-day period. Is the original subvention enough to bring it within the prohibition on the electioneering communication, and B, is that constitutional?
Well, again, it wouldn't qualify as an electioneering communication under BICRA because that statutory definition only applies.
You're right. I stand corrected. If the statute covered that as well, if the statute covered the book as well.
I think the use of labor union funds as part of the overall enterprise of writing and then publishing the book would be covered.
That would be enough to bring it in, and
I don't.
That
but
constitutional.
And I think it would be constitutional to forbid the labor union to do that. Whether it would.
And just to follow up, even if there's one clause in one sentence in the 600-page book that says, in light of the history of the labor movement, you should be careful about candidates like John Doe who aren't committed to it.
Well, whether in the context of a 600-page book that would be sufficient to make the book either an electioneering communication or
Well, it does by its terms, doesn't it? Published within 60 days. It mentions a candidate for office. What other qualification is there?
Well, I think the Court has already crossed that bridge in Wisconsin Right to Life by saying the statute could constitutionally be applied only if it were the functional equivalent of express advocacy. And so that would be and we accept that constitutional holding. That would be the relevant constitutional question. I wanted to return for a second, Justice Alito, to a question you asked about the purported interchangeability of the Internet and television. And it's certainly true that a growing number of people are coming to experience those media as essentially interchangeable. But there are still a lot of people either who don't have computers at all or who use their televisions and their computers for fundamentally different purposes. And I think it's evident that Citizens United perceived the two media to be distinct because it was willing to pay $1.2 million to a cable service in order to have the film made available by video on demand when Citizens United could have posted the film on its own website, posted the film on YouTube, and could have avoided both the need to make that payment and the potential applicability of the electioneering communications.
If they had done either of the things you just mentioned, putting it on its own website or putting it on YouTube, your position would be that the Constitution would permit the prohibition of that during the period prior to the primary or the election.
Our position is not that the Constitution would permit it. Our position is that BICRA wouldn't prohibit it because those are not covered media. Now,
would the Constitution, if BICRA, if Congress in the next act covered that in light of advances in the Internet, would the Constitution permit that?
Yes. I mean, the Court in McConnell upheld the electioneering communications on their face, and this Court, a majority of this Court in Wisconsin Right to Life, said those provisions are constitutional as applied.
I'm really disoriented here, Mr. Stewart. We are dealing with a constitutional provision, are we not, the one that I remember, which says Congress shall make no law abridging the freedom of the press? That's what we're interpreting here?
That's correct.
Okay.
But again, the Court obviously has grappled in the past with the question of how to apply that provision to use of corporate treasury funds, either for express electoral advocacy or its functional equivalent.
But in this case, Mr. Stewart, I take it, correct me if I'm wrong, that you think the distinction the petitioner draws between the 90-minute film and the short 30-second or 1-minute ad is a baseless distinction.
It is of no constitutional significance. Congress certainly could have drafted the electioneering communication definition.
So if we think that the application of this to a 90-minute film is unconstitutional, then the whole statute should fall under your view.
Well, I think
because there's no distinction between the two.
Well, I think the Court has twice upheld the statute as applied to communications that are the functional equivalent of express advertising.
But I'm saying that if we think that that this film is protected, and you say there's no difference between the film and the ad, then the whole statute must be declared.
It would depend on the ground under which you reach the conclusion that this film was protected. If you disagreed with our submission and said there is a constitutional difference between 90-minute films and 60-second advertisements, then